These discrepancies confirm what we suspected. The shipments didn't make it past this bridge.
So they must be stashed somewhere close by. I understand this is difficult, but you need to sign these documents immediately, or the sheriff will have to intervene.
The very first letter hit my mailbox like a threat. Notice of violation. It screamed in bold, as if I'd committed a crime instead of buying land. I remember standing on my porch, coffee in hand, rereading it twice, waiting for the punchline. But there wasn't one. I'd owned my property for exactly 9 days, and a nearby HOA one I wasn't even part of was already ordering me to correct unsightly conditions and cease disruptive activity. The funny part, I hadn't done anything yet. The scary part, they clearly thought they could control me. My name's Evan, and I bought 1,500 acres in a rural pocket outside a growing suburban area rolling pasture. A strip of timber and a river that cut through it like a dark ribbon. The land had been on my radar for years. It used to belong to an old family ranching outfit, and when the last owner passed, the heirs finally decided to sell. It wasn't cheap, but it was the kind of place you don't find twice. Space to breathe. Room for a small cattle operation, and quiet that felt like medicine. The only catch was the neighborhood. Next door, an upscale HOA community called Riverstone Cove. Picture perfect lawns, matching mailboxes, and rules for everything from fence color to where you could park a boat. They had built their entire development along a bend of the river like it was a private resort, and their entrance road ran near the edge of my new land. I didn't think much of it. I wasn't joining their HOA. Their rules weren't mine. Or so I assumed. That first letter claimed my new construction plans violated their scenic view protections. I almost laughed because I hadn't even applied for permits. The only thing I'd done was bring in a skid steer to clear storm-fallen limbs along an old ranch track. But the HOA president, Marla Dent, had apparently seen machinery from her morning walk and decided I was an enemy. I set the letter on my kitchen counter and told myself, ignore it. People like that thrive on reactions. 2 days later, a second letter arrived. This one was nastier. It accused me of creating noise pollution, lowering property values, and operating commercial equipment near a residential zone. It ended with a line that made my jaw tighten. Failure to comply may result in legal action. That's when I realized Riverstone Cove wasn't just nosy. They were organized, confident, and used to getting their way. The kind of people who treat the county like their personal customer service line. I called the number on the letter. A calm receptionist answered, Riverstone Cove Homeowners Association. I asked politely why I was receiving violations when I wasn't a member. After a pause, she said, Our board believes your activities affect our community. I asked to speak to Marla. Another pause. Then, she's unavailable. Please submit your concerns in writing. That told me everything. They didn't want a conversation. They wanted compliance. I decided to handle it like an adult. I drove to the county clerk's office, pulled the plats, and reviewed the property boundaries. My 1,500 acres were exactly that mine. No shared parcels. No HOA covenants on my deed. Not even an overlap. Still, I wanted to understand how they felt entitled to police me. That's when I noticed something interesting on the map. Riverstone Cove sat on what was basically a peninsula formed by the river and a steep ravine. There was only one paved road in and out of there. What neighborhood? A narrow 2-lane stretch called Orchard Spur. An Orchard Spur crossed the river on a short bridge, nothing dramatic. Just concrete and steel, but the bridge sat right where my land pinched close to the water. I leaned closer to the map and felt my stomach drop. The bridge was drawn inside the boundary line of my property. That couldn't be right, could it? I asked the clerk if there was a separate right-of-way. Document for Orchard Spur. She pointed me toward a thick binder of easements and county road orders. After an hour of digging, I found the crucial detail. Parts of Orchard Spur were county-mained, but the bridge itself had a different history. Decades ago, the ranch owners had built it as a private crossing to move equipment between fields. Later, when Riverstone Cove was developed, builders had tied their entrance road into it. Here's the problem. The documents showed the county never formally accepted the bridge into its road system. The HOA's developer had relied on a handshake arrangement and temporary construction access, promising they'd handle final access agreements. Then the developer went bankrupt mid-project. A new company finished the neighborhood, and everyone just kept driving over the bridge like it was public. Over time, people forget what's legal and start treating habit like law. I left the clerk's office with copies in my passenger seat and a strange feeling in my chest, half disbelief, half dread. Because controlling a bridge isn't like owning a fence line. A fence line is private. A bridge is power. It's emergency vehicles, delivery trucks, school buses, and every resident's daily commute. And I didn't want power. I wanted land and quiet. But now I was holding a card Riverstone Cove didn't even know existed. That night, I reread the HOA letters and noticed the tone. They weren't asking. They were commanding. If they were willing to bully someone they thought was helpless, what would they do if they realized I had leverage? I decided on one rule. I wouldn't threaten. I wouldn't bluff. I would stay calm, stay legal, and protect my property rights without turning into the villain of my own story. The next week, I started my actual project, restoring the ranch. I brought in a small crew to repair old fencing, clear invasive brush, and mark boundaries. I also had a surveyor confirm corners because I didn't want a single inch of doubt. That's when Riverstone Cove escalated. A black SUV rolled up to my gate, and two people stepped out wearing polo shirts like they were on an official mission. One introduced herself as Marla Dent. Marla didn't greet me. She scanned the land behind me like she was inspecting a messy room. "We need to talk about your operation," she said. I told her calmly that it wasn't an operation, it was my property and I wasn't in her HOA. She smiled without warmth. "Your choices affect our residents. We have guidelines for maintaining the character of this area." I almost asked if she heard herself, but I held back. Then she said something that made the air go cold. "We've already spoken to the county about your equipment and your plans. They're reviewing your permits." I told her I hadn't filed permits. Marla's smile faltered for half a second, then returned sharper. "Regardless, we'll ensure compliance." She handed me a folder like she was serving papers. Inside were printed HOA bylaws, a neighbor expectation sheet, and a demand that I meet with their board. I took the folder, looked her in the eye, and said, "I'll review anything the county sends me. But your HOA rules don't apply to me." Marla's voice stayed sweet while her words turned pointed. "You might be surprised what applies when access and services are shared." At the time, I didn't realize she was unknowingly walking right up to the bridge issue. She was trying to imply she had leverage over me. She didn't, but I did. A few days later, I got a call from the county planning office. The woman on the line sounded tired before I even said hello. "Mr. Hale," she said, "we received multiple complaints from Riverstone Cove about noise and land use." I explained what I was doing: basic restoration. Agricultural use, no commercial business open to the public. She sighed in relief. "That's what it looks like. You're fine, but they're persistent." Persistent was an understatement. Riverstone Cove residents started stopping along the fence line to take photos of my crew. One guy shouted that I was destroying the view. Another told me I couldn't have cattle that close to homes. Then the HOA posted on their community page that I planned to build an industrial farm. Someone even reported to animal control that my land was unsanitary, even though I didn't have animals yet. It was harassment dressed up as concern. I decided it was time to stop guessing and start documenting. I installed trail cameras on my side of the fence, not to spy, just to catch trespassing. I also started keeping a simple notebook: date, time, who showed up, what was said. I hated doing it because it made me feel paranoid. But I'd watched friends get steamrolled by paper trails they didn't create themselves. If Riverstone Cove wanted a fight in official channels, then I would be ready. Then the moment came that turned everything upside down. One morning, my foreman told me a delivery truck had nearly clipped the bridge guardrail on Orchard Spur while hauling landscaping stone into Riverstone Cove. The driver said the bridge felt soft under heavy load. That got my attention. If the bridge was on my land and privately built and something happened, an accident, a collapse, who would they blame? The HOA, the county, or the guy whose property it sat on? Me? I hired a structural engineer to inspect it. 2 days later, he met me at the bridge with a clipboard and a serious face. He tapped concrete, checked joints, and crawled under with a flashlight. When he came back up, he said, "This bridge is overdue for maintenance. It's not about to fall tomorrow, but it's carrying loads it was never designed for. If heavy trucks keep using it, you're going to have a real liability problem." That night, I barely slept. Because suddenly, the bridge leverage wasn't just leverage, it was responsibility. I called my attorney, a practical guy named Ron who didn't waste words. I asked him 2 questions. Do I own the bridge? And what happens if someone gets hurt? Ron reviewed the documents and said, "You likely own it? Yes. And liability depends on a lot: signage, knowledge, negligence. But the bigger issue is access rights. Do they have a recorded easement?" Ron's assistant dug deeper. The answer came back clean and terrifying. There was no permanent recorded easement granting Riverstone Cove the right to use that bridge. There were old temporary construction easements, expired. There were proposed access agreements, never filed. There was county maintenance on road segments, but not acceptance of the bridge. It was a legal gap everyone had stepped over for years without noticing. Ron said, "You need to address this before it becomes a lawsuit." So I did the responsible thing. I sent Riverstone Cove a certified letter. No threats, no attitude, just facts. I explained that I'd confirmed ownership issues regarding the bridge, that an engineer had flagged maintenance concerns, and that I wanted to meet to discuss a formal access agreement and shared maintenance plans, something recorded, legal, and safe. I even offered to host the meeting on neutral ground at the county mediation office. I thought they'd be relieved. I was wrong. Marla responded with an email so bold, I stared at it like it was satire. She wrote that Riverstone Cove residents had uninterrupted access rights and that I was attempting to extort the community. She claimed the bridge was effectively public and demanded I cease interference immediately. Interference. I hadn't blocked anything. I hadn't even posted a sign. But Marla's message made one thing clear. They were going to treat my attempt at cooperation as weakness. The HOA board called a special meeting. And somehow video from it ended up in my inbox, sent by a resident who apparently still believed in fairness. In the clip, Marla stood in front of a projector screen showing an aerial map of my ranch. She pointed like a general planning a campaign. "We cannot allow him to turn that land into a nuisance," she told the room. Then she said the line that changed everything. "If he wants to play hardball, we'll remind him who controls his access, too." That was the moment I realized Riverstone Cove didn't just want peace. They wanted dominance. They thought they could pressure the county, weaponize complaints, and bury me in legal fees until I surrendered. And the irony was painful. The one piece of infrastructure that actually controlled access, the bridge, was the very thing they were ignoring. Not because they were confident, because they hadn't done their homework. Ron advised me not to self-help in any aggressive way. No barricades, no surprise closures. He said the clean approach was post-safety signage. Limit heavy loads if the engineer recommended it, and demand immediate negotiation for a recorded easement and maintenance obligations. Your goal, he said, is to reduce liability and get clarity. If they refuse, then we go to court for declaratory judgment. I didn't want court. But I also refused to be bullied, so we took the engineer's report and did something simple. We posted signs at both ends of the bridge. Private bridge load limit 1 OTONS. Use caution, contact owner for commercial oversize access. That was it. No threats, no drama, just safety. And immediately, Riverstone Cove exploded. Marla emailed again, calling it an illegal blockade. Residents started posting photos online, claiming I was trapping them. But cars still crossed easily, even SUVs, even ambulances. The next escalation came fast. A landscaping company contracted by the HOA tried to drive a fully loaded dump truck across anyway. My foreman stopped them, pointed at the sign, and asked them to turn around or unload. The driver argued, said the HOA told us it's fine. My foreman didn't raise his voice, he just called me. I called Ron. Ron called the company and said, "You've been warned in writing. If you cross and damage the bridge, you're liable." The truck backed up. That afternoon, I got a knock at my gate. A county sheriff's deputy stood there, polite but cautious, like he'd walked into a neighbor feud that could go sideways. "Mr. Hale," he said, "we got a call that you're blocking a public road." I showed him the documents and the engineer report. He studied them quietly, then said the words I'll never forget. "This is civil, not criminal, but you should probably keep everything calm." Then he looked at the bridge and added, "That sign makes sense." Word traveled. Within 2 days, 2 different Riverstone Cove residents visited me privately without Marla. The first was an older man named Raymond who'd lived there since the first homes were built. He apologized for the HOA's tone and admitted something shocking. "We always assumed the developer handled the bridge. But after the bankruptcy, a lot of paperwork got messy." Marla doesn't like admitting that. The second was a mom named Tessa who said, "I just need to know my kids can get to school." I told both of them the truth. Nobody was trapped. Nobody was being punished, and I wanted a legal, safe agreement. But I also told them something else. The HOA's constant complaints and threats were making cooperation harder. "If Marla wants war," I said, "we'll end up in court, and that helps no one." Tessa nodded, like she'd been waiting to hear an adult speak. Raymond promised he'd push for a calmer board discussion. The following week, Riverstone Cove's attorney sent Ron a formal letter. It claimed the HOA had a prescriptive right to use the bridge due to years of continuous access. Ron explained to me what that meant. In some cases, long-term use can create rights. But it's not automatic, and it depends on whether the use was adverse, open, and without permission. Their argument, Ron said, is basically, we've been using it a long time. So, it's ours now. Then he added, "A judge may not love that attitude." Ron responded with a measured offer. We'd grant a permanent recorded easement for standard passenger vehicles and emergency services. Immediately, if they agreed to a cost-sharing maintenance contract and a truck route plan that kept overweight vehicles off the bridge until repairs were made. We also asked for one non-negotiable clause. The HOA would stop harassing my ranch operations and stop filing frivolous complaints, unless they had legitimate legal grounds. I wasn't asking them to like me. I was asking them to behave. Marla rejected it publicly. She held another HOA meeting and told residents I was trying to control their freedom. She left out the engineer report. She left out the liability. She left out the part where her neighborhood's access paperwork was incomplete. Instead, She fired up the crowd with a simple villain story. Rich landowner buys ranch and tries to trap our community. That narrative spread fast until one resident asked a question Marla couldn't dodge. If he doesn't own the bridge, why are we so scared? A week later, the county got involved, not because they wanted to, but because Riverstone Cove wouldn't stop calling. A county engineer met us on site. He examined the bridge, reviewed the file history, and confirmed what my engineer had said. The bridge wasn't formally adopted by the county, and it needed upgrades if it was going to carry modern neighborhood traffic long term. Then the county engineer turned to the HOA's representatives and said, "You need a recorded easement and a maintenance plan. This isn't optional anymore." That's when the power shifted. Suddenly, Marla wasn't speaking like a conqueror. She was speaking like someone watching the floor drop out from under her. Riverstone Cove realized their options weren't bully Evan or make Evan comply. Their options were negotiate like adults or risk a court battle where a judge could impose terms they didn't like. And if the bridge ever failed, the whole neighborhood would be front-page news for the worst reason imaginable. The final meeting took place in a plain county conference room with stale coffee and fluorescent lights. I came with Ron, my engineer's report, and a proposal that was firm but fair. The HOA board arrived with their attorney and Marla, looking tight-lipped. For 3 hours, we hashed out details: weight limits, repair timelines, cost splits, insurance, and a permanent easement recorded against my property. In exchange, the HOA agreed on paper to stop interference with lawful ranch work and route heavy trucks another way. In the end, I didn't trap anyone, and I didn't turn the bridge into a weapon. I turned it into a reality check. Within 6 months, Riverstone Cove paid their share to reinforce the bridge, add safer rails, and install proper signage. Deliveries adapted, emergency access was protected. And the harassment stopped almost overnight because the HOA finally understood I wasn't a target. I was a neighbor with rights. And every time I drive past that bridge now, I don't feel power. I feel relief because the only thing stronger than leverage is a deal that keeps everyone safe.